The main differences between state and federal gun charges in PA. There are large differences between state and federal gun charges. We own guns. We understand gun law. We'll represent you in state and federal court with gun charges. Let's take a look at the differences in the laws. Pennsylvania state-based prosecution. Under Pennsylvania state law, the major firearms offense in Pennsylvania for illegal possession of a gun is called persons not to possess, use, manufacture, control, sell or transfer firearms. You can read the statute here. 18 PS Section 6105. For anyone to be guilty of this offense, the government must prove beyond a reasonable doubt the following. A person must have been convicted of an offense enumerated in this section, or exhibit conduct that meets one of the other listed categories, and possess, use, control, sell, transfer or manufacture a firearm in this Commonwealth. Subsection B of this statute lists 37 felonies that count as disqualifying convictions for this purpose. If you are convicted of any of these felonies, you may not possess firearms. There are also several other categories under which possession of a firearm is illegal. These groups include persons addicted to controlled substances, dishonorably discharged from the military, or committed to mental institutions, as well as several other groups. Pennsylvania also adds to these individuals who have been convicted of 3 or more duis in the past 5 years. Federal-based prosecution. The federal government has a similar but slightly different law called unlawful acts. You can read the law here. 18 U.S.C. Section 922, G. For a defendant to be guilty of this crime, the government must prove beyond a reasonable doubt. The accused is part of one of the prohibited categories, and the accused possess, transport, or ship a firearm. All of the federally prohibited categories are the same as Pennsylvania's categories except DUI convicts, who are not barred federally. The major distinction is that federal law does not list any included felonies. They just simply state that the prohibition covers anyone convicted of any felony. The federal definition of a felony is any offense where the total authorized maximum sentence is greater than 1 year. It does not require 1 year be imposed, just that the authorized punishment is 1 year or more. There is one out that Pennsylvanians have that other states don't have. In states like PA that have state misdemeanors that are punishable by more than 1 year, such as Pennsylvania misdemeanor of the 2nd degree, those unique folks convicted of a PAM3 or PAM2 can possess firearms. However, if the misdemeanor is a crime of domestic violence, then they are subject to the same firearms restrictions as felons. What other Pennsylvania gun charges exist? Carrying a firearm without a license. Under certain conditions, Pennsylvania state authorities can prosecute someone for concealed carry of a firearm without a license. Except for cities of the first class, Philadelphia, as long as someone is not a prohibited person, a license to carry a firearm is not needed to open carry a firearm. The government must prove the following elements beyond a reasonable doubt to gain a conviction for carrying a firearm without a license, under Section 6106(a). The accused carried a firearm, basically meaning a modern handgun. It does not include a long gun or NFA item, on one's person or in one's vehicle, with some exceptions. The accused did not have a valid license to do so. Our Pennsylvania Supreme Court recently declined to announce a bright-line rule as to what is concealed and what is not. This leaves it up to the jury to decide on a fact-by-fact basis. This law does not apply to members of law enforcement or military, or to private citizens who are traveling to and from recreational target shooting, and some other exceptions that are beyond the scope of this article. Further, there is a sportsman's permit exception, which allows those who have a hunting license to carry their firearms to and from the location where they are hunting, as well as while doing so. Section 6106(b), c. Minor in possession of a firearm. One final PA firearms law to note prohibits minors, under 18 years old, from possessing firearms, modern handguns. In Pennsylvania, this is governed by Section 6110.1, possession of firearm by minor. There are 2 elements to this offense. The accused is under the age of 18, and that person possessed or transported a firearm, basically a modern handgun, within Pennsylvania. Only 2 exceptions exist. The possession occurs under parental supervision or when the under 18-year-old is lawfully hunting or trapping. Additionally, the government can charge any adult who gives a minor a firearm to a minor under Section 6110.1 c. Responsibility of adult. The elements of the crime are: an adult who knowingly delivers, and intentionally delivers, a firearm to a minor. To knowingly deliver a firearm to a minor, an adult would have to be practically certain his or her conduct, delivery of the firearm, will cause the result, possession by the minor. Section 302 b. 2. To intentionally deliver a firearm to a minor, an adult would have to have delivery be his conscious object, meaning it is his purpose to do so. Section 302 b. 2. Here are some more differences between state and federal gun charges. Juveniles and handguns. Federal law only prohibits juveniles, same definition as minor, from possessing handguns or their ammunition, an offense governed by Section 922(x). The elements of this offense are: a juvenile knowingly possessed a handgun or handgun ammunition. The definition of knowing here is the same as before, meaning the child must be aware that he or she is possession of a handgun. This statute also contains a provision like Pennsylvania's responsibility of adult offense. The elements of this offense are: an adult must sell, deliver, or otherwise transfer a handgun or its ammunition to someone the adult knows or reasonably believes to be a minor. This means that not only is it possible to be guilty of this offense if you deliver a handgun to someone who you are aware is a minor, but also if you suspect they may be one and have a reason for this suspicion. Several exceptions exist, like in cases where the gun is needed for employment, is used under parental supervision, or in accordance with law. Section 922(x). Other federal charges, statutes and the maximum penalties. Sale of illegal firearms. Transferring an NFA item without a proper form of FFL, 0.18 U.S.C. 922. 10 years. False statements on the 4473 form or straw man purchase, 18 U.S.C. 922. A. 6. 10 years. Illegal possession of a prohibited firearm, violation of the NFA Act. Illegal possession of a prohibited firearm, violation of the NFA Act. 18 U.S.C. 922(0). Use of firearm or possession of firearm during drug dealing or violent crime. 10-year. 18 U.S.C. 924(c) varies depending on conduct. Illegal sale of firearm without a FFL, in the business of. 18 U.S.C. 922(a). 5 years. Violation of the Gun-Free School Zones Act. 18 U.S.C. 921(a). 25, and 18 U.S.C. 922 5 years. Additional charges that FFLs can face. An FFL is a federal firearms licensee. If a person is engaged in the business of selling or transferring firearms, federal definition, that person must be an FFL. If he or she is not, then they are subject to prosecution. Federal law on firearms mostly concerns the licensing of dealers who do business across state and national borders. This means that only licensed dealers may buy and sell firearms across these boundaries. Section 922(a). There are also prohibitions against licensed dealers selling to persons not present on the date of transfer. Section 922(c). Transporting packages containing firearms without written notice. Section 922(e). And the sale or transportation of stolen firearms. Section 922(i)(j). And firearms without a serial number. Section 922(k). Can I be prosecuted in both state and federal court for gun charges? Yes. For over 170 years, the courts have said it is possible. It does happen. The courts have found that the federal government and the state government are separate and distinct sovereigns. As such, someone can be twice prosecuted for the same exact conduct in both federal and state court. Any sentences, by U.S. Code, must run consecutive, one right after the other. If that happens, this simultaneous prosecution for the same offense does not violate double jeopardy. What is the definition of firearm, gun, and the difference between PA and the federal definition? In legal scenarios, The term used for gun charges is firearm charges. The federal definition of a firearm is broader than most would assume. It means any weapon that can be used to expel a projectile via an explosion. It also means the frame of such a weapon, or the silencer of a firearm, or any destructive device. Section 921. The statutes define a destructive device as anything from bombs to grenades to propellable rockets. This definition differs from the one Pennsylvania law offers. While the federal definition specifies the functions of firearms, the Pennsylvania definition specifies the lengths of weapons that fit in this category. Specifically, a shotgun with a less than 18-inch barrel, a 16-inch or less barreled rifle, and a pistol, revolver, rifle, or shotgun with a total length less than 26 inches all count as firearms. Section 6102. It also explains how the barrel of a firearm is to be measured. From the muzzle to the face of the closed-action bolt or cylinder. The term firearm in PA specifically does not cover long guns. Interestingly, and to add to the confusion, Pennsylvania occasionally adopts the federal definition of a firearm in some places in the law. So the definitions in PA as to what makes something a firearm is a difference between state and federal gun charges. Does possession or using a firearm result in mandatory minimums or sentencing enhancements in the state and federal system? If so, what does the government have to prove to get the mandatories or enhancements? Here are some more differences between state and federal gun charges. Frequently, firearms charges come with heavy sentences. In the federal system, this is governed by Section 924, which details the minimum sentences for all the above-mentioned offenses. Specifically, as we talked about above, when it comes to possession, brandishing or discharging a firearm during drug dealing or a crime of violence under 924(c) do have mandatory minimum sentences depending on the conduct. In the federal system, the 922(g) charge in and of itself does not carry with it any mandatory minimum charge. See 18 U.S.C. 924(c) 1. A statutory maximum sentence under 924(c) is a life sentence. Here are some of the mandatory minimums. Using or carrying or possession, in furtherance of, drug trafficking or a crime of violence equals 5-year mandatory minimum. Brandishing, displaying, a firearm, in furtherance of, drug trafficking or a crime of violence equals 7-year mandatory minimum. Discharging, firing, a firearm, in furtherance of, drug trafficking or a crime of violence equals 10-year mandatory minimum. Possession of a SBR, SBS or AR-like firearm, in furtherance of, drug trafficking or a crime of violence equals 10-year mandatory minimum. Possession of a machine gun, more than one bullet per pull of the trigger, DD or suppressor, in furtherance of, drug trafficking or a crime of violence equals 30-year mandatory minimum. If you have a prior enhancement under 924(c), the mandatory minimum is 25 years. If you have a prior enhancement under 924(c), and the new charge has an enhancement under 924(c), involving a machine gun, more than one bullet per pull of the trigger, DD or suppressor, then the mandatory minimum is life. Pennsylvania gun charge mandatory minimums. On the books in PA, Pennsylvania law also has minimums for firearms offenses. We can find these at Section 9712 and Section 9712.1. These state laws deal exclusively with the use of firearms while committing other offenses. Therefore, under Pennsylvania law, ordinary possession offenses do not carry mandatory minimums. The reality of PA mandatory minimum for gun charges. Luckily, several United States Supreme Court cases have ruled that any fact that would lead to a mandatory minimum being used needs to be proven by a jury. Accordingly, the provisions in Section 9712 and Section 9712.1 that say these facts may be determined solely by a judge have been ruled unconstitutional. This is a good thing because it prevents a judge from increasing a person's sentence on a whim at sentencing. It forces the government to prove the existence of this firearm in the criminal context beyond a reasonable doubt.